Thanks for tuning in. In this video, we're going to discuss the International Entrepreneur Parole Program and pick up where our earlier video on the program left off. In our earlier video, we looked at what International Entrepreneur Parole, or IEP, is and who might consider applying for it. In this video, we'll get into the details of how to apply for IEP and what the application process looks like. As a bit of background, in May of 2021, the U.S. Department of Homeland Security announced that it is relaunching the International Entrepreneur Parole Program. IEP is a program that gives entrepreneurs who own a startup with high growth potential the opportunity to build their startup in the United States, and by doing so, to provide a significant benefit to the U.S. Entrepreneurs who are approved through the IEP program are allowed to remain in the U.S. for up to 5 years in order to develop their startup. The program gives entrepreneurs the ability to apply for an initial period of 2.5 years of parole. After that, the entrepreneur can apply for another 2.5 years, which is called re-parole. The requirements to apply for initial parole are a little different from the requirements to apply for re-parole. In this video, we'll focus on initial parole, that first 2.5 year period. In order to receive parole under the IEP program, applicants must be a qualifying entrepreneur that has a qualifying startup that has received a qualifying investment. We'll cover each of these 3 requirements, but at this point, it's important to note that if you can't satisfy the qualifying investment requirement, the government does allow another option. We'll discuss that later in the video. So let's talk about the first requirement. What is a qualifying entrepreneur? For the purposes of applying for initial parole, a qualifying entrepreneur is someone who owns at least 10% of the startup. The entrepreneur must also have a central and active role in the startup and be in a position to help it grow and be successful. The second requirement, that the startup be a qualifying startup entity, means that the startup must have been established in the U.S. no more than 5 years before the application is submitted. The startup must also show the potential for rapid business growth and job creation. So let's talk a bit about the third requirement and what a qualifying investment is. A qualifying investment can be either a capital investment from qualified U.S. investors or an award or grant from the government. The investment must be at least $265,000 if it's from a U.S. investor. If it's from the government, the amount must be at least $106,000. Keep in mind that a qualified investment cannot come from the entrepreneur or their family. In general, it must be from a firm with an established record of investments, and that is majority owned by U.S. citizens or green card holders. For entrepreneurs who otherwise qualify for IEP but whose startup has not yet received a qualifying investment, there is another option. If the startup hasn't received a qualifying investment, the entrepreneur can instead provide additional evidence of the startup's potential for rapid growth and job creation. The government will accept a broad range of documents to show this, but the evidence should be, to use the words of the government, reliable and compelling. Examples of reliable and compelling evidence that the startup has substantial potential for rapid growth and job creation can include documents that show the entrepreneur's academic background or prior success at operating a business and creating jobs, evidence that the startup has been selected by a startup accelerator or incubator, publicity about the startup's national impact or social impact and any positive effects on the area where the startup is located, or media coverage showing that the entrepreneur or startup has received attention. Evidence can also be corporate or tax records showing the number of customers the startup has, revenue generated by the startup, and jobs created by it. Evidence of other investments or fundraising by the startup, such as through crowdfunding. Letters from the government, such as specific agencies, investors, or business associations with knowledge of the startup's product or services, or the entrepreneur's skill set and experience, or patents awarded to the startup or entrepreneur. Keep in mind that this is not an exclusive list, and you can think creatively about what evidence you might include in your application. Keep in mind, this is no time to be humble, so share whatever puts you and your startup in the most impressive light. So that covers how an applicant qualifies for initial parole, but what is the application process? The first step to apply for IEP is to file an application, which is called a Form I-941 with USCIS. Along with the form, you would include all supporting documents, which we touched on earlier, and that are detailed in the form's instructions. You would also include your payment for the filing fee and biometrics fee, which totals about $1,300 as of the time of this video. After filing the Form I-941, the government will notify the entrepreneur where they can submit their biometrics, whether at a consulate or at a USCIS field office. Once USCIS approves the I-941, the entrepreneur is said to have received conditional approval for parole. The entrepreneur must then visit the U.S. consulate in order to receive a boarding foil in their passport. With the boarding foil, the entrepreneur can then arrive at a U.S. port of entry, an airport or a border crossing, for example, and request entry. At the moment they are allowed entry, they have officially received parole. The actual grant of parole is made at the port of entry by an officer with U.S. Customs and Border Protection, or CBP. A common question that comes up is whether an entrepreneur can apply for parole under the IEP program from inside the U.S. The answer is yes. An entrepreneur can apply for parole under the IEP program from within the U.S. since the foreign entrepreneur can file the I-941 with USCIS while they are either inside or outside the U.S. However, since parole is granted by CBP at a port of entry, the entrepreneur must actually depart from the U.S. and seek entry at a port of entry in order to be granted parole. For Canadians, the process is slightly different. Canadians do not need to have a travel document, such as a boarding foil, from a consulate before approaching the port of entry. Instead, they can request a parole at a U.S. port of entry by presenting an approved I-941. We hope you found this video helpful. If you did, please click the thumbs up button and subscribe button below to stay updated on future videos about visa options and travel to the U.S. Thanks for watching.